Today's lecture is titled When Trademark Owners Act Like Infringers. And in the lecture, I'll be talking about this phenomenon that I call ownfringement. What is ownfringement? It's a combination of ownership and infringement, that owners are acting like infringers. So what does that mean? Well, that means that trademark owners are now doing things that they never would have done beforehand, but they would have pursued third parties for doing them. I'll give you a few examples of what I mean. So, for example, competitors are collaborating. And not only are they working together, but they're using each other's signature aspects, their marks, in a spliced together fashion. So for example, Gucci and Balenciaga have collaborated, and there is a Gucci mark all over Balenciaga products, or a Balenciaga mark all over Gucci products. And that's unheard of before. If Balenciaga had slapped the Gucci mark all over its own products, Gucci would have been filing a lawsuit very fast. Another instance or category of how this is happening is when there are these companies in distant spaces that are collaborating in ways that almost defy expectation, where it's almost shocking and surprising that they're collaborating. One suspects that they were not, but they are. And so, for example, Dolce & Gabbana has collaborated with appliance maker Smeg to put the Dolce & Gabbana art on Smeg appliances that they then sell. So that's a new, unusual phenomenon that's been increasing. A third way in which this is happening increasingly is businesses engaging in self-parody. And they may be doing this to poke fun at some larger phenomenon, often playing around with authenticity. And Gucci itself has done this by misspelling its mark in its authentically released products as Gucci rather than Gucci. And this is poking fun at knockoff culture, but with a huge price tag because it's an authentic product. And these are in fact things that the trademark owners would have gone after in the past, but they're now increasingly engaging in it. How long this trend will last, it's unknown, but it does warrant a pause to reflect on what this means for trademark doctrine, because it's so antithetical to the way trademark law expects businesses to operate in terms of using their mark clearly in a non-confusing way. And so in particular, in the lecture, I reflect on a number of central doctrines of trademark law: the likelihood of consumer confusion, the notion of distinctiveness in trademark law as a requirement to have protection, and dilution doctrine, as well as the parity defense, and how this might affect our thinking in these contexts if businesses continue to engage in this way. I'm very excited to be in Singapore. It's my first time here, and I've been wanting to come here for a long time, even before the Crazy Rich Asians phenomenon, although that definitely personified a lot of the very exciting things about Singapore. And I've been very excited to see the architecture here. I think it's just fabulous and imaginative, and I love the way the architecture and just, the ethos here is really a mixture of innovation and tradition, and there's a colorfulness and a whimsicality, but also a seriousness to it. And so I've really enjoyed all of that. And so it's been quite fun going to the shopping here, which is both over the top and fabulous, and rivals New York City, where I'm from. And as well as looking at the ways that technology and nature come together, such as at Gardens by the Bay. I really enjoyed seeing that. So I've been loving it here.